Welcome to Bankruptcy Bytes, a video series presented by the United States Bankruptcy Court for the Eastern District of Missouri. My name's Matt Rodman, Attorney Advisor to the Clerk of Court, and today's topic is debtors' duties in bankruptcy. For all the benefits a debtor can receive in bankruptcy, there are certain responsibilities and obligations that they must fulfill to receive this needed relief. It is extremely important that the debtor pay close attention to the responsibilities and obligations placed upon them when filing a bankruptcy case. Your case may be dismissed if you do not comply with certain statutory requirements imposed by the Bankruptcy Code, as well as deadlines imposed under the applicable federal and local rules of bankruptcy procedure. Here are some important duties you should know before filing a bankruptcy case. To start off, debtors in both Chapter 7 and Chapter 13 cases must obtain credit counseling before filing their petition. This credit counseling course must be completed within 180 days prior to filing. A list of approved credit counseling agencies can be found on the U.S. Trustee Program's website. A link to the U.S. Trustee Program's website can be found in the video description below. Next, in addition to the petition, creditor matrix, verification of creditor matrix, and the filing fee, which are all due at the time of filing, you must also file all required statements and schedules required by the Bankruptcy Code and Federal Rules of Bankruptcy Procedure within 14 days after you file your case. Please note that the requirements for filing under Chapter 7 and Chapter 13 slightly differ. A list of filing requirements for Chapter 7 and Chapter 13 cases can be found on the court's website at www.moeb.uscourts.gov. Debtors in both Chapter 7 and Chapter 13 cases are obligated to provide the court with a correct Social Security number or taxpayer ID number. If the debtor realizes that the information on their petition or Form B-121 are incorrect, they must file an amended petition or amended Form B-121 to correct the error. Information on amended filings can be found in the court's local rules of bankruptcy procedure posted on its website. After the amendments have been filed, the debtor must also send a notice of corrected Social Security number or taxpayer ID number to all creditors and major credit reporting agencies. Lastly, the debtor must file a certificate of service that includes the names and addresses of each person or business that was notified of this error. Debtors must provide the trustee with pay advices or wage statements from their employer for the 60-day period prior to filing their case. Debtors must also complete Local Form 36, titled Statement Under Penalty of Perjury Concerning Payment Advices and Tax Returns. Local Form 36 can be found in the Forms section of the court's website on the list of Chapter 7 forms and Chapter 13 forms. If for some reason the debtor does not have these pay advices or wage statements for the 60-day period prior to filing their case, their Local Form 36 should reflect that by selecting the appropriate option on the form. Please note, a separate Local Form 36 must be prepared by each debtor in a joint case. Local Form 36, the pay advices or wage statements, or another verified statement must be provided to the trustee prior to the Section 341 meeting of creditors as specified in the local rules of bankruptcy procedure. Additionally, debtors must provide the trustee with a copy of their most recent federal tax return and complete the portion of Local Form 36 concerning those tax returns. Copies of a federal tax return can be ordered from the Internal Revenue Service. If for any reason you did not need to file a tax return for the most recent tax year, your Local Form 36 should reflect that by selecting the appropriate option on the form. Debtors must attend their Section 341 meeting of creditors. The Section 341 meeting of creditors is typically held within 2 months after the case has been filed. Shortly after the case is filed, the court will send a notice to the debtor and all creditors listed on the creditor matrix with the name and contact information of the trustee assigned to the case, as well as the date, time, and location for the Section 341 meeting of creditors. Debtors in all cases must understand that they have an ongoing obligation to be open, honest, and transparent with the court. This means ensuring the accuracy and completeness of all schedules, statements, documents, pleadings, etc. that they may file with the court. For example, if you have a domestic support obligation such as child support or alimony, you are not only responsible for maintaining that obligation, but you must also make sure that that domestic support obligation is properly disclosed on your schedules. Another example. If you are involved in a lawsuit or cause of action at the time your case is filed, you must disclose that lawsuit or cause of action on your schedules. As soon as the debtor realizes that an error or mistake has been made on a schedule or statement, the debtor must file an amended schedule or statement, as well as a memo describing the error and what has been changed on the amended schedule or statement. Additionally, the debtor must serve that amended schedule or statement on all affected parties. Information concerning amended filings can be found in the court's local rules of bankruptcy procedure on the court's website at www.moeb.uscourts.gov. Debtors in both Chapter 7 and Chapter 13 cases must complete a course in personal financial management, or debtor education, prior to being eligible to receive a discharge and have their case closed. In a Chapter 7 case, this course must be taken within 60 days after the Section 341 meeting of creditors. In a Chapter 13 case, this course must be taken prior to your last plan payment. A list of approved debtor education providers can be found on the U.S. Trustee Program's website. A link to the U.S. Trustee Program's website can be found in the video description below. Debtors in Chapter 13 cases must also file a plan and start making payments to the trustee within 30 days after filing their petition. This is an example of where Chapter 7 and Chapter 13 cases slightly differ. The intent of this video is to provide a broad overview of the duties and responsibilities that every debtor will encounter in bankruptcy. Depending on the unique circumstances of your individual case, there may be additional duties and responsibilities placed upon you. The best way to ensure that you are keeping up with all of your duties and responsibilities in bankruptcy is by consulting a bankruptcy attorney. A bankruptcy attorney will be well versed in the bankruptcy code, the federal rules of bankruptcy procedure, the local rules of bankruptcy procedure, and the court's procedures manual. All of this combines to provide the roadmap for a successful bankruptcy case. The court strongly urges debtors to consult a bankruptcy attorney to determine if bankruptcy is right for them. If you would like to speak with an attorney regarding your recent or upcoming bankruptcy filing, the Bar Association of Metropolitan St. Louis hosts the St. Louis Bankruptcy Pro Se Assistance Program. This program offers cost-free 30-minute sessions with an attorney where the prospective or current debtor can get the answers to some of their questions. To schedule an appointment, you may call 1-844-758-4059 or schedule online at www.bamsl.org/bankruptcy. Thank you for tuning in to Debtors' Duties in Bankruptcy, part of the Bankruptcy Bytes series presented to you by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, Attorney Advisor to the Clerk of Court, and on behalf of the Clerk and all of the clerk's office staff. We hope you find this information helpful, and we wish you all the best moving forward.